Hey, welcome to Sekulow. What we are talking about is potentially the beginning of the end for Roe versus Wade and this doctrine set up by the Supreme Court, again, in the 1970s, that has been fought out in the states. It's been fought out at the federal level, but there has not been a case that was quite on point on overturning the precedent in Roe versus Wade, which is a serious challenge at the Supreme Court when the Supreme Court, if they do decide to reverse previous precedent, those are about the biggest cases available. But they also are the most uphill challenges, the most difficult challenges. There's a reason why it's been since 1973 to get a case like this to the U.S. Supreme Court. Mississippi has done it through a 15-week a ban on abortions after 15 weeks, like a pain-capable abortion bill. There are exceptions there, but their attorney general specifically asked for Roe and the Casey cases to be overturned, for those precedents to be overturned. We have a total of 3 different clients and briefs that we're working on at the ACLJ on different angles. Yeah. Even Europe is weighing in, our European Center for Law and Justice, because we know even some of those justices on the left end, they love looking at European law.
Right. So
and European law is way more restrictive on abortion than the United States.
The United States has the most aggressive abortion stance in the world as far as allowing abortion to the point of delivery. So what happens here is this is the first case in my lifetime where there has been a direct, real challenge to the underpinnings of Roe versus Wade. When I say direct, real challenge, Roe versus Wade has been the law of the land for 50 years. It's called stare decisis. And Andy Ekonomou, our senior counsel, let's go over what that is for a moment, because we're asking in our briefs also for that precedent to be overturned. What does stare decisis mean? Because I think people need to get an understanding of exactly what we're dealing with here.
Jay, stare decisis is a principle of law. It's a judicially constructed principle that says cases based on the same facts and the same law should be decided in the same way. In other words, there gives some stability to the law, which means that if you have an expectation that certain things are going to happen in certain ways, you can rely on the law in a better fashion to come up with a more equitable result, so that all cases that are factually the same and legally the same are decided the same. But that is a judicially created law. That means it can change. And the Supreme Court has gotten it wrong several times in the past. The Dred Scott decision, Plessy versus Ferguson, Korematsu, were the interning of Japanese Americans, and has come out later and said, we got it wrong. Right. And stare decisis does not permit us to continue the wrong that has been worked. We hope the same thing happens in Roe v. Wade.
Well, here's what we say. The Constitution does not confer on this court, talking about the Supreme Court, rulings a status supreme to the Constitution itself. In other words, the court is not supreme to the Constitution. So when the court makes a mistake, and as Andy just said, Plessy versus Ferguson, Korematsu, there's a whole list of cases, they overturn themselves. This is not written in stone, so to speak, and that's why this is the real challenge on this issue, and that's also why your American Center for Law and Justice is working on 3 different briefs, including our European Center for Law and Justice, that will be filing a major brief in this case as well.
I mean, this is, again, from Mississippi's brief to the Supreme Court. The grounded question becomes whether this court should overrule the decisions in Roe and Casey. It should. The stare decisis case for overruling Roe and Casey is overwhelming. They are egregiously wrong. So Mississippi, they're defending their 15-week abortion ban, but directly put at issue Roe versus Wade and the Casey versus Planned Parenthood case. It's now heading to the U.S. Supreme Court. And when we come back, we're going to walk through the different briefs we're filing, different briefs, not just one that the ACLJ is filing with the Supreme Court. Support our work, the ACLJ Matching Challenge. Double the impact of your donation at aclj.org. That's aclj.org. We'll be right back. So the case at the U.S. Supreme Court is Dobbs versus Jackson's Women's Health Organization. This was a challenge by an abortion, the abortionist in Jackson, Mississippi, against a Mississippi law banning abortion after 15 weeks. And they are challenging directly the precedent in Roe versus Wade and Casey versus Planned Parenthood about viability, that science, technology has come a long way. There is a reason why the Supreme Court has upheld bans on partial birth abortion when states have enacted that, and at the federal level,
right, because
technology has come a long way. That was a while ago now. That was 20 plus years ago now, and technology has come that much further. So there are different arguments that Mississippi is making, but we're also then taking this opportunity, this unique opportunity where the party at issue, the state, most of the time when this would have happened, the state would have not wanted to put an issue directly overturning Roe versus Wade. They would have ignored it almost.
Right.
This Mississippi has said, no, we can't keep playing this game of trying to work around a flawed holding by the Supreme Court, a flawed precedent in Roe versus Wade and the Casey case. So there's that issue. There is the issue, again, the scientific issue. There's a precedent issue, and that all is being briefed differently because you know the justices who don't want to change Roe versus Wade on the left, all they're going to want to point to directly is precedent, stare decisis. We can't get involved
Right,
here.
and we just talked to Andy about stare decisis, but I'm holding two of the briefs, but there's a third one being prepared by a European Center for Law and Justice. C.C. Heil is a senior counsel for us and is very involved in these issues and very involved in our work overseas, especially our European Center for Law and Justice. C.C., let me go to you on this. This is the first direct challenge to Roe versus Wade head on that we've seen, especially with the conservative Supreme Court. Now, we'll find out how these courts view stare decisis. And again, if you're just joining us, that is the rule of precedent. But precedent can be wrong, as we've said. What's your sense of where this goes? And then we'll talk about the ACLJ brief for a moment.
Well, I agree with what you and Jordan have stated, that the liberal judges will go with the stare decisis opinions of we've got to follow Roe v. Wade. And hopefully the conservative judges will follow the Constitution. And as we have stated over and over again, there is no right to abortion found in the Constitution. And Roe v. Wade has been attacked by legal scholars on the left and the right. So not just conservative legal scholars, but even liberal legal scholars as a bad decision. So this is a great opportunity for the court to get it right.
Walter Weber is senior counsel and really does a tremendous amount of work on the Supreme Court issues that are in the ACLJ and has been for over 30 years. Walter, we say in our brief the Constitution does not confer on this court, meaning the Supreme Court's rulings, a status supreme to the Constitution itself. Again, that's kind of battling the stare decisis issue, but give us an overview of what we're saying in these briefs.
Sure, Jay. Well, one of the problems that we face is that the Supreme Court has acted as if it is the Constitution, that whatever it says becomes part of the text. That's not what the Constitution says, of course. The only way to amend the Constitution is by either a state convention or by a proposed amendment from Congress. So when the Supreme Court says we have a decision, we know it's wrong, but we're going to follow it anyway, then what they're saying is that our rulings take a higher priority than the Constitution itself, which is itself an unconstitutional approach to take. That's one of the points that I think is important to convey to the court. We've also pointed out that there's an irony here in that the Supreme Court prior to Roe versus Wade had no problem with abortion being part of the state law homicide and other state regulations. In other words, Roe versus Wade itself did not follow stare decisis. So that would be really weird to say, well, we changed the law dramatically in 1973, and now we have to leave that unconstitutional decision in place as a matter of stability.
Well, it's interesting to me, Andy. This goes back to the stare decisis issue, and that is this. You took a Dred Scott, where the Supreme Court said that Black Americans were entitled to 3/5 recognition, not full recognitions as human beings and as citizens. That's number one. That was the Supreme Court of the United States. Karematsu, where Japanese Americans were interned, and the Supreme Court said, yes, they can be. Obviously wrong. So when the Supreme Court gets it wrong, which they do, there has to be a way to connect it. Stare decisis does not put the court's opinions over the Constitution.
No, it does not, Jay. Stare decisis, as I said, is a judicially created principle. It doesn't exist in the Constitution. There is no such thing as stare decisis. You're not going to find those words in the Constitution of the United States. That is a judicially created principle that says cases decided on the same facts and on the same law should be decided in the same way. But That does not stand in the way of the Supreme Court, or any court for that matter, saying we decided this case wrongly to begin with. There is no constitutional right to an abortion. It doesn't exist in the Constitution. We have gotten it wrong, and we need to say that we have gotten it wrong, just as when the Supreme Court upheld the internment of Japanese Americans during World War II on the basis that they were a threat to the public because of their Japanese ancestry. Nonsense. And the same thing with the Dred Scott decision about a black being three-fifths of a white or something like that. Or Plessy versus Ferguson saying that schools can be separate, but they have to be equal. You got it wrong, you change it, you declare that you were in error, and you go the right way, the constitutional way.
And CC, what unique thing that is this time around for the ACLJ is the ECLJ, the European Center for Law and Justice. Our director there, Greg Orr, contact us about the ECLJ preparing a brief to inform the justices on the state of the law in Europe and inside the European Union. And to really, I think it's probably surprising to a lot of our listeners that in the European Convention on Human Rights, there's no right to abortion. Europe is not more liberal than the U.S. when it comes to this issue. In fact, much more conservative. As we point out in this brief, 45 out of 47 member states of the European Union prohibit abortion before 22 weeks. So they already prohibit partial birth abortion in the vast majority of European nations.
That's correct. And so just like you said, most people would think that Europe is more liberal than the United States, but on abortion, they are not. The European courts, basically our brief states that how the European courts deal with the issue of abortion and how the 47 member states of the Council of Europe how they legislate on abortion. And we point out that the European Court has stated that the European Convention on Human Rights and its right to life does apply to the unborn baby. And so all of the legislation in the 47 member states then has to comply with that. And as we see, the vast majority, 45 of the 47 member states of the Council of Europe, they restrict and prohibit abortion well before the point of viability, well before it.
And I think this is the first time ever that the European Center for Law and Justice, and we are kind of directly, I think, going at the left, because the left has, for time and time again, especially Justice Breyer specifically, has wanted to use European law. They want to bring in European norms. What are the international norms? Right. Well, the international norms here in the other developed nations around the world and our closest allies and partners around the world is that they think this is barbaric and don't allow it.
That's exactly right. And you're right when you say Justice Breyer. Justice Breyer, who has been on the Supreme Court now for a long time, does look at European law, and he looks at it as the influence and kind of trend setting. I mean, that's the way he views European law. I also know this. It's important for our audience to understand this, that our briefs have been cited by both conservative members of the Supreme Court and liberal members of the Supreme Court. So, Andy, when we've got or let me go to Walter, actually. Walter, in this particular case, we're hitting a host of issues. And obviously this is going to come down to where the newly appointed justices end up.
Yeah, well, Jay, I figure the role of an amicus brief in a Supreme Court case is to give the court ammo to come out the right way. We're trying to make it easy for them to do the right thing. So you and Jordan were talking earlier about the barbarity of abortion as recognized in Europe. Okay, so what do we do in our brief? We point out the comparison between the kinds of things that are forbidden as cruel and unusual punishment to the most vile convicted murderers. And it's the same techniques that they're using in abortion. We point out animal cruelty laws and the horrible things that could be done to animals that would never be allowed in the United States, but it's the same thing that's being allowed to unborn babies. So that kind of extreme cognitive dissonance, that inconsistency between the way the law treats what everyone else would otherwise recognize as, of course, horrible and barbaric, and yet is somehow okay in abortion, that's the kind of thing that we hope will convey to the court that they've just got to fix that mistake in Roe, because it just does not fit in. It doesn't work. It makes no sense according to the rest of the law.
Andy, really quick, like in 15 seconds, I want to make this point very clear. Stare decisis is not a bar to the Supreme Court coming out with the right decision here.
No, it is not a bar. It is a judicially created principle that espouses the idea that cases decided the same way should be decided the same way on the same facts and law. But it does not prohibit the Supreme Court or any court from saying we got it wrong and we need to rectify it by reversing Roe versus Wade in this case.
And for too long, the court has relied on these precedents to try and not handle issues directly that are controversial, and there's nothing that prevents them. There's no reason they don't have to follow precedent. They don't have to follow, and in this situation, when science, technology has significantly changed, and you can look and see the development of the child in the womb, this should be the time when they step in. They say, okay, we were wrong. This court was wrong. We'll be right back on Sekulow. All right, welcome back to Sekulow. We're getting right to the phones. Frank is calling in from Florida online, too. Hey, Frank, welcome to Sekulow. You're on the air.
Thank you for taking my call, gentlemen. My question is this. In this case, Roe v. Wade, does the President of the United States have an objection or would have an objection if it were overturned?
Well, let me say something first, and then, Jordan, you respond. I suspect the Department of Justice is going to be filing a brief on this case, putting forward the administration's view, which I can guarantee you is that Roe versus Wade is good law. That's how they view it. But go ahead with it. But there's been a political side of this, too.
Yeah, that's right. I mean, Jen Psaki, White House press secretary, has already spoken out, and this is what they said President Biden would be willing to do if the court were to take the action that we support. Take a listen, bite two.
The president is committed to codifying Roe, regardless of the outcome of this case.
Now, what does she mean by that? Making it the legislative law. This is not, and this is what's interesting. There is not legislation and a law. It's the court that legislated here. And in the legislation, by the way, he could want to do that all day and night, and it does tell you where he is. But with the makeup of Congress right now, there's no way that would happen. So they know that this is where they're going to do a build up to if this case were to go the way we want. We got to pack the court. We have to change the court, but they don't have the votes yet. And I think this is what
but they're going to use this as a rallying cry.
Oh yeah, definitely. So, I mean, if it goes the way that we want,
should. Now, here to get to the point about what will DOJ do. Well, listen to Jen Psaki again, the president's White House spokesperson. They're telling you what's coming, folks.
We are supporters, the president is a supporter of preserving Roe v. Wade. That is our position. In terms of a legal reaction, I would point you to the Department of Justice.
So the pointing to the Department of Justice, of course, Andy, means that the Department of Justice is, like us, going to file a brief in this case.
Oh, yes, they'll file a brief in this case. There's no doubt about that. And they're going to mount the position of this piously Roman Catholic president, Joe Biden, in favor of abortion. I don't understand that at all. But that is going to be the position, and it's a wrong position. It's a wrong position constitutionally, legally, and it is not barred by stare decisis.
I want to talk about the moral implications of this, too. This is the taking, Cece, of a human life. And I think what we have to remember at the beginning of this, that's what this is all about. It's not, yes, stare decisis is the constitutional principle, due process clause, was there a right to create Roe? But at the end of the day, this is also a moral issue. It's about the taking of a life.
Right, absolutely. An unborn baby is a life that deserves protection, and our Constitution protects it. Our founding documents and our Constitution protect the right to life. And the Supreme Court got it wrong when they decided, well, but life doesn't really begin, or the protection is not compelling until this arbitrary point of viability outside of a mother's womb. And so, yes, the bottom line is life is protected by our Constitution. It needs to be protected, and life begins at conception, and these unborn babies need to be protected.
Let me talk to Wes Smith, taking off your military hat, just as a chaplain in the military and a pastor. I want to talk about the moral implications of it, but we are talking about human life here.
Yeah, we are. I was thinking about some of my ethics training in grad school about these kinds of issues. This is the biggest moral issue we face as a nation since the abolition of slavery. It is a moral issue. It's the central ethical debate of our time. I was listening to an abortion advocate on television this morning, and she stated the decision to have an abortion is so personal, and she worried that the legal right to terminate a pregnancy might be taken away from women, and she implied that that itself would be immoral. There is no legal or inherent right, or should not be, to take a human life other than some form of self-defense. That's Ethics 101. The choice to take a human life has serious, serious moral implications. This is why the death penalty, Jay, is such a matter of serious debate, and some states have outlawed it. Viability with the baby has placed an even greater emphasis on this. The bottom line is this: whatever a woman's justification for the right to end a human life, we have to be clear on this, the moral issue. It is a human life, and she is choosing to end that human life. It is a moral issue.
With the sanction, Jordan, of the state. Now, they will, if this decision goes the right way, this will be a rallying cry, of course, for their pack the court, change the rules.
Yes, but I think at the end of the day, the American people, that's going to be
puts it
front and center. This is an issue that the American people, when they are confronted with it, and not just a general idea of should abortion be allowed or not allowed, but should we be able, as a state, as a society, a civil society, to be able to say, you know what, this is when we're going to stop this. And in Mississippi's case, they are using the latest technology and the science to say, you know, we don't allow late-term abortions in America in most states. Some states do, like New York, California, some of the more liberal states, as you said, they allowed almost up until birth, partial birth abortion. But there have been bans on partial birth abortion that have been upheld by the Supreme Court, by Congress. There have been, most states don't allow abortion, late-term abortion. And in this situation, what was late-term with technology in the 70s and 80s, you can now see that after just weeks, after 15 weeks, you could consider that late-term abortion. There are children being born that weigh a pound and surviving now very early in pregnancies and having healthy lives because of the where technology is. And they are experiencing what is once they're born, they get all of those rights. The question is, when do those rights kick in inside the womb? That is the question we're still grappling with as a nation. And as our European Center for Law just points out, this whole idea of privacy, like Wes was talking about, this is a very private decision. Europe rejected that as an argument. Europe said you can't use privacy when you're talking about the taking of the ending of this life, whether you want to call it a child or a fetus, it is ending a life.
Yeah, well, and there are liberal judicial scholars and constitutional scholars that have said, while they agree, Andy, with the right to abortion, they disagree with the underpinnings of Roe versus Wade.
That's correct. The underpinnings of Roe versus Wade, I think, have been seriously eroded since it was decided almost 50 years ago. And we think we have to come to a realization, Jay, and we have to come to a declaration that it is not the law. It is not good law. It is contrary to the science that Jordan adverted to. It is contrary to the Constitution of the United States. There are balancing factors. And I think one of the things that you mentioned earlier, Justice Breyer is very much intrigued by the influence of international law. I wonder if this intrigue that he has with thinking about the law of nations internationally is going to make an effect on him, since the European Center for Law and Justice, our affiliate in Strasbourg, France, is weighing in on this case.
That's exactly why we're doing it. I mean, that's exactly why we're filing that brief, CC, is exactly on that point, to underscoring what Andy said.
Absolutely. And once again, most people would think that Europe is more liberal than the United States, but they are not. They absolutely acknowledge the European courts. The European Convention on Human Rights gives a right to life, and the European courts acknowledge that that right to life extends to the unborn baby. So now you have competing rights. You have to acknowledge the right of the baby in the womb with the right of the mother. And we just do not do that in the United States.
You know, I think what we have to understand is that the ACLJ, we're taking this opportunity to support what Mississippi is doing in an unprecedented way. 3 unique briefs, 3 unique issues. We'll walk through those again for you the second half hour again, how we're kind of working through this. There's the stare decisis issue. There's the scientific issue. There's the international issue. And the ACLJ taking up not in one brief, but separating it out. And of course, you can stand with us, support the work of the ACLJ, Stand for Life. We have a matching challenge right now. You double the impact of your donation to the ACLJ at aclj.org. That matching challenge goes until the end of this month. aclj.org. Donate today.
When a woman gets pregnant, their motherly instincts just kick right into gear. It's how we're wired, it's how we're created, and I short-circuited mine.
I still remember staring up at that bright light and counting backwards from 10.
It was very, very painful. I've never felt pain like that in my life. I remember the nurse giving me sedation, and she just kept rubbing my arm, shushing me.
I didn't want the baggage because I had a vision for my life, and it didn't include children.
When I found myself pregnant, Roe v. Wade had just happened. It was all in the news. I called my doctor. He said, no problem. We can take care of it.
I was told that it was just a blob of tissue. I wasn't given any choices as far as ultrasounds or why don't you go home, think about it, and then come back. Nothing like that. There was nothing positive.
When I stood up, I fainted. I think I fainted because of the horror of what I had done. I realized that I was missing a large part of me.
I actually ended up being pretty volatile and got a little physical with the nurse. I slapped her across the face. And I remember because I didn't want anyone to see me. I didn't want anyone to know. They don't let you walk back out the front. There's a private exit. And later on in life, I wondered, had I seen someone like me in the state I was in at that moment after that abortion walk out, back out the front clinic, maybe I wouldn't have done it.